This is Friday, September 18th, 2020. Yesterday was Constitution Day, by the way, and the President gave the Constitution Day address. This is our last day of discussing the Constitution, and we're going to finish by, of course, turning to the last part of the Constitution, which is the amendments. On Monday, we'll turn to the next thematic division in the course, which is the issue of federalism, of the division of authority and function between the national and state governments. And I'll pass out PRQs and notes for that over the weekend. So, if you're looking at the notes, there are 27 amendments, which means it's a remarkable thing that the Constitution has endured so long and under so many crises and has been amended so infrequently. Some states in the Union, like Illinois, have gone through 3 state constitutions since the beginning because they add so many amendments that the constitutions become cluttered and they have to sort of draw up new ones. So the framers' constitution has proved to be pretty enduring and pretty flexible. So to help you, I'm not going to ask you to stand up and recite every one of the 27 amendments, but perhaps I should. Anyway, I'll give you 3 different approaches to help you assimilate the material in the amendments and what they do, and those 3 approaches or 3 ways of dividing the amendments up are historically, the mode of ratification. It turns out there's only one that fits into there, as you'll see, and then what they actually amend in the Constitution. And there are, in turn, 3 additional categories of what kinds of things that amendments tend to amend in the Constitution. The first thing is individual rights and liberties. They either add a security or add a right of liberty or expand it, the liberty of individuals or the rights of individuals. The second thing is they often change an institution in the Constitution. And then the third category is, of course, miscellaneous. If you're going to have categories, you always have to have them miscellaneous to make sure that you have something to contain examples that don't quite fit into anything else. So let me remind you that all of the amendments were added to the Constitution after the Constitution was completed, and pursuant to the procedures in Article 5, which I talked about on Monday, but I'll review them with you. Just a little bit of history. The Constitution was, in some states, as we learned, was very close to not passing and being successfully defeated. And in some ways, there were 2 major, and to go back to the Federalist Papers, once the Constitution was submitted to the nation, then dueling newspaper editorials spread up all over the country, and there were talented people on both sides. Again, generally speaking, the supporters of the Constitution were called Federalists, and the opponents were called Anti-Federalists. And oftentimes the writings in the press would correspond to each other and address each other. And in the same way that the Federalist Papers were gathered together into one volume, and of course, there's nothing that compares to them, both in terms of their relevance to the Constitution and their depth and complexity. There were also anthologies of anti-federalist writings too, and we will examine some of those later on in the course. Now, generally speaking, the 2 most stringent exceptions, no, 3. There were 3 major exceptions that tended to arise and sort of follow the Constitution and threaten to overrule its ratification. 1, there was the general belief among the opponents of the Constitution that the national government was too powerful. Everyone had admitted that the government of the Articles was too weak, but many critics of the Constitution thought that it had gone too far in addressing the weaknesses of the Articles by creating an overly strong and centralized national government. Now, as we'll work through the rest of the course, we'll see that there may be some truth to the charge that the tendency over time of the Constitution is to concentrate authority in the national government. But on the other hand, you could say this, that the opponents of the Constitution generally didn't grasp the new areas of theory such a separation of powers and checks and balances that the Constitution embodied. And that doesn't mean that the product that the framers created was perfect, but yet you'd have to say that um, they did in fact try to divide the powers and functions of the national government between the state and the nation, the states and the nation, and as you'll see to some degree, that arrangement, that part of the Constitution, as we'll discover next week, has always been a little messy. But nevertheless, you could have to say that the design of the Constitution has endured. The second issue was uh, people thought that the presidency was too strong. Uh, Again, they understood that you had one of the great failings of the Articles was that there was no executive branch, and that the executive branches under the states were weak and manipulable by the legislatures. But um, but generally speaking, in the same way that they thought the critics thought that the national government was too strong, they thought that the presidency came too close to a monarch. One of our most famous patriots from the Revolutionary period is Patrick Henry, and he stood up in the Virginia Ratifying Convention and thundered out, "The presidency is the fetus of monarchy." So that was also a persistent criticism. And the third major criticism was it had no Bill of Rights. Now that's a complicated issue, as we'll see, uh, and part of the reason people wanted a constitution to have a Bill of Rights is almost all the state constitutions were prefaced by bills of rights, and and some of the framers thought that in a founding document, one that was designed to last for ages, you should probably put the rights of the people up very visibly. Not so much that they could be used by the courts to restrain the powers of government, but they kind of stand as a kind of a permanent billboard of the nation's freedoms. So, as um, the Constitution was ratified, more and more ratifying conventions adopted the Constitution on the promise that one of the first things that would happen in the new government would be amendments to the Constitution. So, as a matter of fact, the Constitution was ratified, and elections were held under it in the fall of 1788, and the Congress first met on March 4th, 1789. That Congress had to do some tasks for the first time. First of all, they had to count the electoral votes, and George Washington was unanimously declared the president, and John Adams was the vice president. The second thing is they had to create the other branches of government. They had to pass the fundamental legislation that organized 5 departments in the executive branch at that time: defense, treasury, interior, um, justice, and I just blanked. Um, and then, and of course, today the executive branch is much bigger. But generally speaking, by the time the government of the Articles ended, you had essentially a few secretaries of departments and about 800 soldiers left. So the Constitution really was starting from scratch, you might say. So they created the executive branch. And the third thing they did was to create the judicial branch. They set up the federal judiciary and the Federal Judiciary Act of 1789 that still essentially governs our courts today. And finally, the fourth thing was, and here's a little irony to it, 11 members of the Constitutional Convention were actually members of the First Congress. They ran for office like Madison. Madison represented his district in Northern Virginia for a couple of years. And so Madison was a member of the House of Representatives. He was so afraid that the push for amendments might lead for the Congress to pose genuinely destructive amendments of the national government's power or structure. Um, and and also he was afraid that if unless something was done and rapidly, that perhaps a certain negative feeling or hostility to the Constitution might grow over time. So he was moved to fulfill the promises of amendments. He was also moved by the practical desire to cement authority and opinion in favor of the Constitution and not lead these um, excuse me, uh, excuse me, um, uh, and not to leave these kinds of resentments and unfinished business over him. So Madison drafted 12 original amendments. Um, and then those were sent to the Senate. The Senate debated and amended them, and then that those were sent back to the House for correction and everything. The congressional record was very skimpy at this time, so we don't have a very full record of those debates. But um, by by the last part of 1789, both houses of Congress, which according to, and so remember, here are the procedures in Article 5. Remember that amendments can be proposed by either the initiation for amendments can either come from within the national government and the Congress, or it can come from the states. And so to propose an amendment, um, 2/3 of both houses of Congress, the House and the Senate, have to agree on proposing an amendment. And again, as I mentioned in class, the president has no official role in this. He only has official power in daily legislation through the veto power. So he so the 12 amendments were codified and rendered identical, and were sent out to the states. And by the end of 1791, and this is why 1791 is the end of the founding period, by 1791, 10 of those first 12 amendments were actually ratified. You're going to see that as the amendments go on, the custom of adding a last line that says, this amendment shall not be operative unless it is accepted or ratified within 7 years of its being proposed. So that wasn't part of the original amendments. So you could say there was an unanswered question in the Constitution. How long could an unratified amendment lay before the country, before 3/4 of the states' legislatures or 3/4 of the states' conventions ratified? Well, nobody answered that question before until one of those originally 12th amendments, those 12 amendments was actually ratified in the 1990s. We'll come back to that in a minute. So the first set of historically clumped amendments were the first 10 amendments, commonly called the Bill of Rights because they generally reinforce or list many of the fundamental civil liberties that Americans had enjoyed both as Brits and as Americans. So that means, by the way, that I actually list it separately. That 12th Amendment that was proposed in 1789 and just kind of lay there in limbo until the 1990s, an enterprising college student went around and started to get a legislative bodies in the states to adopt them. And so that 27th Amendment, one of the first ratified and the last, one of the first proposed and the first last ratified, said that a full year has to occur before a voted pay raise of Congress goes into effect. So in essence, it's a kind of a check on Congress's power to raise its own salary. The next set of historically clumped amendments are the 13th, 14th, and the 15th Amendments. Those are commonly called by historians the Civil Rights Amendment because they followed immediately as a course of the Civil War. The 13th Amendment, as we discussed earlier this week, the 13th Amendment is the first time that the Constitution mentions slavery in order to abolish it. Remember, in all the other three parts of the original Constitution, slavery was referred to, or slaves were referred to as persons whose liberties or rights were taken away by the laws. So the 14th Amendment then, and the 13th Amendment was passed in 1865, just as before Lincoln had been assassinated, just after Lincoln had been assassinated. And the 14th Amendment then was drafted and came in 1868. And here was the issue there. After the 13th Amendment liberated the former slaves, most of the people who had been slaves previously remained in the South. They had been granted land grants there by the Freedmen's Bureau, and also they had a kind of an attachment to the land. But almost all of the original 11 Confederate states, right after the conclusion of the war, passed what are called the Black Codes. And these codes were very restrictive of black people's liberty. In Mississippi, for instance, you couldn't, if you were a black person, you couldn't walk unaccompanied on the streets after 6 p.m. unless you were accompanied by a white person. You couldn't walk like 2,000 cubits outside of the town boundary. You couldn't sue a white person. So clearly, the the states were trying to reimpose certain conditions of limited freedom on the African American populations. And so the 14th Amendment does several things at once. And in history, it turns out that the 14th Amendment is the single most consequential and important amendment in the Constitution's fabric. Here's a little bit more of history. You remember that we discussed the Dred Scott case in 1857 as one of the catalysts of the Civil War. In that case, remember, Justice Taney declared that Dred Scott, the individual Dred Scott, had never become a free man when his master took him first to Illinois and then to Minnesota, but that he never could, and nor could any African American ever become a citizen of the United States. Now, I agree with Lincoln that that was an extremely problematic and shoddy opinion. Nevertheless, as we talked in class, he probably had several motives for that. One of them was to preserve the reputation of the founders, and another was not to increase the tensions that might explode into war. So, Dred Scott. So, what enabled Taney to conclude the Dred Scott case with this remarkably unhinged, sweeping statement regarding the non-suitability of black people for American citizenship? It's because the original Constitution had a kind of a defect. They were great men and smart and everything, but they couldn't do everything, and they couldn't fix everything at once. So it turns out that the national Constitution contained no explicit definition of citizenship, and that's what enabled Taney to craft this wide-ranging opinion that actually denied citizenship to African Americans because there was a gap there. That gap was completed by the 14th Amendment, which at the same time overturned the holding in Dred Scott. There have been a few constitutional amendments which have come into being, like the 16th Amendment on income taxes, because the Supreme Court held a controversial decision. And so this is one way that if you're unhappy with a judicial decision in the lifelong judiciary, you can always get a constitutional amendment, because a constitutional amendment, the authority of the Constitution, trumps federal judges. So the 14th Amendment starts out by saying all persons born and naturalized in the United States and subject to the jurisdiction thereof shall be citizens of the United States and of the state wherein they reside. So Taney had, in Dred Scott in 1857, had sort of said the reason that black people can't be citizens of the United States is states can make them citizens of their own state, but they have no general right to compel other states to accept them as citizens. So Dred Scott overturned, the 14th Amendment overturned the Dred Scott decision, and it filled in that original gap. It now defines national citizenship as birth or naturalization, and state citizenship as residency, which means, obviously, state citizenship is less fundamental. Then the 14th Amendment goes on to address the specific issues of the deprivation of the civil rights of African Americans as their former freed slaves. The next three clauses go: all privileges and immunities of the citizens of the United States shall not be abridged or denied by a state. No person shall be deprived of due process of law, of life, liberty, or property without due process of law. Nor shall any person within the jurisdiction of any state be denied the equal protection of the laws. So those three clauses are called the Privileges and Immunities Clause, the Due Process Clause, and the Equal Protection Clause. So, of course, that didn't solve the problem of race, but that's why that amendment was passed, because you had to add to the national government's power over the civil rights of Americans, because it was the states who were abusing them, contrary to the expectation of the Anti-Federalists. So, as I said, The third historical grouping is the 27th Amendment, because it's the only amendment that has sat around for over 200 years and was finally passed. So historically, the amendments may be grouped into the Bill of Rights, the first 10 amendments, the Civil War amendments, the 13th, 14th, and 15th amendments, and that little old doggy of an amendment, the 27th Amendment, trying to catch up with the others. The second way you can arrange the amendments is by their theme or their content. That is to say, what kind of change do they actually initiate in the Constitution? And what we'll do is on the notes, I made a comprehensive arrangement of the Bills of Rights, both with respect to the rights that they expand and also the amendment, the number of the amendment, and by the way, I've added something here. You could, generally speaking, the First Amendments, the First Amendment to the Eighth, Ninth, and 10th Amendments follow an order, and it's the same order that you see in the three branches of government, and the same order that you saw in the charges against the king in the Declaration of Independence. Broadly speaking, you will see that there is a set of rights that are addressed to Congress, that they put limits on Congress's legislative power, so Congress can't pass laws that deprive people of these fundamental freedoms. Then the Bill of Rights turns towards protecting people in their homes against police quartering of troops, which means they're forced to live there. And so, but also, that's the Third Amendment. The Fourth Amendment protects people in their homes against unreasonable police actions. And as we'll see, I'll finish this when we actually go through it. The Fifth, Sixth, and Seventh Amendments are actually the trial amendments, the court amendments. So generally speaking, as you move from the First Amendment to the later amendments, you're moving through the branches of government: Congress, the police and administration, and the courts. So, what are the specific privileges which the amendments either strengthen or fortify or protect certain immunities? Well, again, the First Amendment puts limits on Congress's power to legislate and take away those rights. The actual opening language of the First Amendment, which is very famous to Americans, is Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So you can just conceptualize it as the First Amendment puts fundamental limits on Congress's power, so that Congress cannot infringe on these rights through legislation. And what are those rights? Religion, both in terms of a non-establishment of religion, but also the free exercise of religion. So the free exercise of religion, speech, press, assembly, and the right to petition the government with a redress of grievances. The Second Amendment also continues the theme, at least for the framers, of a fundamental right, and that's the right to bear arms. There's controversy in our constitutional interpretation as to whether or not the real aim of the Second Amendment was to protect individual ownership of weapons, or whether or not the purpose was to make sure that the states had access to their National Guard and militia. The Supreme Court, by the way, only decided on the individual character of the right to bear arms only about 10 years ago, in 2010. So the First and Second Amendment, fundamental rights of self-expression and liberty, and the right to bear arms. The next two amendments, the Third and Fourth Amendment, have to do with executive and police authority. As I already mentioned, the quartering of troops, because that's what the king's troops did. The king did that during the Revolutionary War, and the colonists hated it so much they put it in the Declaration of Independence. They put it in the Constitution. And so far as I know, never has a foreign troop been quartered in a private person's house. So no quartering of troops. But then also the protection of security against unreasonable searches and seizures by the police of your house and persons, and also, as an additional protection, the requirement of the policeman, when possible, to go get a warrant of, that is to say, a judicial order that allows him to search your house. The next amendments now take you into court, the realm of the courts and judicial procedure and criminal procedure. The Fifth Amendment, so what's happening, if you can see it, is, of course, you're moving from the outside and the police, where they arrest you, the status of being accused, and then the status of receiving a trial. So the Fifth Amendment opens up with 5 fundamental rights. The right to due process, the right to a grand jury in capital cases that involve a murder, no ex post facto law. No deprival of, no taking of private property by public authorities without substantive compensation, and the no double jeopardy. I just forgot the I forgot to put it down, so I had to think about it. So the Sixth Amendment then goes to the actual trial, and that's where Americans are guaranteed a fair trial, an open trial, a public trial, and a trial by the jury of one's peers, and also a representation by an attorney. The Seventh Amendment is a dead note. It's just a dud, and that it requires in civil cases where the monetary value of the award is higher than $20, it goes into federal court. Well, obviously, that amendment has been rendered obsolete. And then the Eighth Amendment is at the end of the criminal procedure, where it says no cruel and unusual punishments, etc. So the first 8 amendments roughly cover the individual in his or her life, starting from what Congress can legislate on to what the police are restrained in their behavior by doing, and what kind of liberties and procedural guarantees people have in the courts. The Ninth and 10th Amendments were added as a result of the ratification debate. The original Articles of Confederation, and we're going to talk about this next week when we read the great court case Marbury v. McCulloch v. Maryland. The original Articles of Confederation said all that the Congress can only, the states retain all authorities and powers over their independence, and only those actions which are expressly granted in the Articles is Congress allowed to do. So obviously, the drafters of the Articles wanted to make sure that Congress couldn't do anything unless it was specifically stated. So the Ninth Amendment is an attempt, so those were Madison's attempt to address the fear of an overly strong national government, at the same time that he really didn't put any serious limitations on the power. The Ninth Amendment says that the rights of the rights not enumerated in the Constitution of certain fundamental rights does not deny or disparage other to the people. What that means is that the Ninth Amendment confirms the notion that you have the right to do anything that is not prohibited. That just because the Constitution specifies certain fundamental rights, that doesn't mean those are the only rights which are available to the people. The Ninth Amendment confirms the notion that there's a broad residuum of personal liberties and immunities out there beyond the enumerated rights in the Constitution. And the 10th Amendment says pretty much what the original article in the Articles of Confederation said, except it leaves out the word expressly. And you're going to see that's a world of difference. The 10th Amendment says the powers not delegated to the national government are reserved to the states and to the people respectively. Again, we'll talk more about those measures. Now, the next set of rights, starting with we've already talked about the 13th, 14th, and 15th Amendments, but now we're looking at them differently. That is to say, what they actually amended, and that is, again, the second category is the expansion or securing of individual rights and liberties. So the 13th Amendment, and they're also called the Civil War Amendments because the 13th Amendment abolished slavery. The 14th Amendment guaranteed equal civil rights for everybody, including freed slaves. And the 15th Amendment prohibited the denial of the right to vote on the basis of race. So each of the Civil War amendments is also an expansion or protection of personal liberty. The next amendment that does this is the 19th Amendment that expands or secures the suffrage, the right to vote for women. The next one can go in either category, the 23rd Amendment, because it granted 3 electoral votes to the citizens of the District of Columbia, because the District of Columbia is not a state, and therefore it has no senators or representatives. But there are a lot of people who live there, and as a result, the 23rd Amendment gives them the right not to have representation in Congress, but to vote in a presidential election. So that's why there are 538 total electoral college votes. The next right to be expanded was the abolition, the right to vote by abolishing poll taxes. The way that some states tried to restrict the vote was by making it too expensive for poor people to vote. And the 24th Amendment expressly denies to states the power to tax the right to vote. And the last major right that's expanded is the 26th Amendment. And that was promulgated in the result of the Vietnam War, because so many young men had been drafted, and so the voting age, there was the slogan that was chanted, old enough to fight, old enough to vote. If you're old enough to be shipped off to Vietnam to die, you should also, as an 18-year-old, have the right to vote. And so the 26th Amendment did just that. So that's why, generally speaking, the history of individual rights and especially the right to vote and participate in the political process has been a gradual process of expansion and broadening. The second kind of change in the amendments is an institutional change, an amendment that changes the nature of an institution or its processes. So, starting with the 11th Amendment, because don't forget the first 10 were the Bill of Rights, the 11th Amendment prevents a citizen from suing his own state in federal court. The 12th Amendment, which we will talk about, very important, it amended the Electoral College. Now, I presume by this point that you have all read Article 2, and you know how the Electoral College is constituted. Well, originally, each elector got 2 ballots and put 2 names on it, expecting that both of those could become president. But then ultimately, when the ballots are collected and sent to Washington, the of the 2 ballots, the one that gets the most names, the most votes, and is a majority becomes the president, and the one who has the runner-up but also has a majority of votes becomes the vice president. The other thing is, in the original Constitution, if nobody gets a majority in the Electoral College, and the Electoral College can't produce a president, then the election, as I mentioned to some students today, goes right to the House of Representatives. So this is called the contingency election. So in the case that our normal way of electing a president can't produce a winner, and to end the confusion and the strife and the tumult of an unresolved election, the framers put what's called the contingency election in. The House goes, the House and the Senate are in joint session anyway, because they're hearing the electoral votes are being counted. If there's no majority winner, the Senate leaves, and the House immediately resolves itself into an election chamber to vote for the president. And when it does that, each state only gets 1 vote. They vote as delegates, and therefore there are only 50 votes for the president. And that's how the House chooses the president in that case. And so what the 12th Amendment did was it lowered the number of runner-uppers from 5 to 3, so as to end speculation and confusion. The next major change was the 16th Amendment, because the Constitution says in Article 1, Section 2, that representatives and direct taxes shall be apportioned across the states by their proportion of the population. Now, you know what that means with representatives. If a state has 10% of the population of the country, they'll have 10% of the representatives of Congress. Direct taxes are a kind of an obscure issue left over from the founding. And they seem to mean, though, that kind of taxation which falls directly on your person, either like a head tax where they just tax like the people in the state or whatever by a common rate of $1 a head or something like that. So what the framers clearly had in mind was, when a tax falls on you, an individual, as opposed to, say, what's called a sales tax or an excise tax. When you buy food in almost every state in the Union and you go into a store, you're paying sales tax on that food, and so that's called an indirect tax because it doesn't hit you; it hits the commodity you're buying. But if it hits the individual, the Constitution requires that it be distributed proportionately among the states. So, when in the late 1890s, Congress passed the first Income Tax Act. It was a relatively minor and flat rate set across the whole country. Because it was uniform across the whole country, uh, uh, some people contested it and took it to the Supreme Court, and the Supreme Court invalidated the income tax. So, in the 16th Amendment, they overturned that. That was the second decision by a court that had been overturned by an amendment and it made the income tax permissible. That's a day we should all celebrate. Then the next important change was the 17th Amendment, which changed the mode of election of the senators from being elected indirectly by the state by being elected by the state legislatures indirectly by the people. And now, after the 17th Amendment, senators are also chosen by the people of that state. I'll just go quickly over the remaining ones. Um, um, the times that the president and Congress began their term in office always was an accident. Our elections have always been held in November because most Americans were farmers and they had to finish with the harvest before they could go into town and vote or mail in their vote. Um, and uh, uh, and so the first elections under the new Constitution for the Congress and etc. were held in the fall. And then by the time that the members of Congress actually finally got there and started setting up the government, several months had gone by, and it was March 4th. So up until the 20th Amendment, our elections have always been held in this fall, but we never inaugurated our newly elected officers until March. You could say, who cares? That leaves an awfully indeterminate time of lame duck inconsistency or uncertainty. And indeed, it was in that period that the 11 states of the Confederacy seceded. So the 20th Amendment moves Congress's point of beginning up to January 3rd because they have to count the electoral votes. And then it has the president being inaugurated on January 2020. So the general thing you have to remember is the 20th Amendment, this was in the mid-30s, moved the time of initiating office from March to January. The 22nd Amendment, it passed in the 50s, limited the president to 2 terms. Originally, the president could be elected any number of times. FDR has the record for 4 elections, and I think people were afraid of the power of a powerful individual to get his hooks in the people. So the 22nd Amendment was passed, which limits the president to a total of 10 years or 2 terms. I mentioned the 23rd Amendment again because you could either view this as an expansion of rights for the voting rights of the people in the District of Columbia, or this is an institutional matter of adding 3 more electoral college votes to the total of the electoral college. That's the 23rd Amendment. The 24th Amendment I mentioned was poll taxes. The 25th Amendment, it immediately became controversial. It's called the Presidential Succession Amendment. And in it, some of the statutory succession, if the president should die or be removed from office, is continued. But the other controversial thing in the 25th Amendment is there is a provision for declaring the president incapable, medically or psychologically incapable of holding office. And some people think that's a ticking time bomb. And it also set up a procedure for where if a vice president is removed from office, as by the way, Nixon, his original vice president was Spiro Agnew. Nixon was almost impeached, as we talked about today, but actually resigned before he was impeached and removed. And Spiro Agnew also resigned so that he could go and face corruption charges when he was the governor of Maryland. Now, the 25th Amendment then sets up an alternative method of choosing a vice president. And that method is the president nominates, and the House of Representatives approves it. And Gerald Ford was nominated as the vice president to take over Spiro Agnew's. And then when President Nixon resigned, Spiro Agnew became the first. I'm sorry. Gerald Ford became the first president not to have been elected by the Electoral College or the people. So, um, um, the last amendment is the 27th Amendment, and I've already told you what that is. It's an institutional amendment. It requires Congress to wait a year before a pay raise that they vote for themselves goes into effect. So you have a way of grouping the amendments by historical clump, the Bill of Rights, the Civil Rights Amendment, and the last amendment of the 27th Amendment. You have a way of grouping them by theme, primarily individual rights versus institutional changes. And the last way of grouping them by theme is miscellaneous. And that refers to the 18th and the 21st Amendment. The 18th Amendment was an interesting experiment in social engineering. It was prohibition. It was a constitutional amendment that made the transportation and sale and manufacture of alcohol impermissible in a state or the country. And it's interesting, you should know this, the question of temperance was actually the issue that actually generated the movement to give women the vote, because the temperance issue in the Women's Christian Temperance Union was one of the major forces that actually got women active in politics. So the 18th Amendment was passed, and Americans immediately fell in love with it. And so it led to corruption and violation of the laws. People became entrepreneurial moonshiners in their backyard or in their bathrooms. And so the American people were given relief by the 21st Amendment, which then permitted the sale and manufacture of booze. So I like to think of the 18th Amendment as no booze, and the 21st Amendment is booze. Now, there's one other uniqueness to the 21st Amendment, and that is it's the only amendment that has been stipulated to be ratified not by the state legislatures, which is the first method of ratification that the Constitution mentions, um, but it also leaves this other method of ratifying by state ratifying conventions, which imitates the way the Constitution was ratified. And so the 21st Amendment was the only amendment that was passed and ratified not by state legislatures, but by state constitutions. That's the amendments. That's the amended Constitution. And so if you have any questions, of course, contact me. You should be doing your PRQs, and I'll send out the notes and the materials for class on Wednesday as we turn to the issue of federalism.